Calvin Green versus Alicia Green. Mr. Green, this is your parenting time complaint, is that correct?
Yes,
You're indicating you did not get your summer parenting time, is that right?
correct.
Okay. And so how did that work? Did you go to pick up the child and the child wasn't available?
Um, this started back in like April that I tried picking her up. She wasn't there, but then she had like a medical problem. So I kind of like, okay, get better. And then um, we haven't gotten back together really.
All right, well, did you have conversations with Miss Green about it, or did you go to the pickup location? So when your parenting time starts, you do the pickup, is that correct?
Yes, I
Right.
used to pick her up from school,
All
but
right.
during our time, I'll go to her, her house, pick her
All
up.
right. Did you go to her house to pick her up in the summer?
Not at that time. No, I did not. Because I've already tried at the school like 5 times and then there was no success. So, and then I asked her, um, when am I going to get to see Elodie again? And I didn't get an answer.
All right, now school has started. Have you tried pickups since school has started?
I've asked them if I'm going to get her this weekend and I'm sick.
All right, Miss Green, what would you like to say regarding this matter?
Um,
Today's case dives straight into the heart of child welfare law. Reunification versus risk. Emily Roman is on the cusp of regaining custody, but two major requirements remain unfinished: parenting training and family counseling. On one hand, she has completed nearly everything else the department required. On the other, the judge sees these missing steps as critical safeguards. This sets up a tense battle. Is partial progress enough to justify returning a child? Or does skipping these two pieces jeopardize long-term stability? The courtroom is about to weigh paperwork, missed appointments, and even the smell of past housing against a mother's determination to get.
I haven't denied him the parenting time because, as a remote worker, I've made sure that Elodie's been, consistency available for visitation. I have not seen him show up to attempt to pick her up. I have not heard from him in that regard. We did attempt mediation on Monday in which my daughter was present, but we were unable to, reach a solution.
Well, a solution on what?
On anything, on coming up with a new parenting time schedule, because at this point in time, besides the fact that he has not attempted to, pick her up that I'm aware of, that he's had minimal communication with my daughter over the past 8 months. And, at this point in time, it sounds like Elodie is, refusing to comply with the visitation order. And, all I can do is encourage her.
What is his pickup supposed to be during the school year?
Her child back. Right away, we hear the department point out the biggest red flag. Emily never actually began the TBR parenting program, despite emails going back to June. Family counseling also fell apart, with one intake and a missed follow-up. In family court, these aren't just boxes to check. They're designed to measure whether a parent can provide safe, stable care after trauma. The irony? She didn't refuse to attend. Scheduling conflicts and communication errors created confusion. Still, from the court's perspective, incomplete is incomplete. Judges have to decide if excuses outweigh the risk of sending a child home too soon.
He picks her up after school on every other Wednesday and every other Friday.
All right. Did you guys make that in order at some point? Because I know the judgment of divorce indicated Fridays at, no, it's just Friday after school, okay. All right, so when is your next weekend, sir? The two of you have an order that you're supposed to have parenting time every other weekend during the school year, correct?
My last one I missed was on the 12th to the 14th, so then it'd be the every other one past that, which is 26th and 27th.
Okay. So on the last one, on that Friday, did you go to school and attempt to pick her up?
She wasn't there.
Okay. Miss Green, was she not in school on Friday last time?
I believe she was sick that day and homesick.
The judge makes a powerful point. What if the child is returned, but Emily still fails to complete the required training? That would mean uprooting the child all over again, compounding the trauma. This is a subtle but critical moment. Family courts don't just look at today's readiness. They anticipate future risks. Returning a child prematurely can do more harm than keeping them in foster care a little longer. This is why judges are cautious, because a second removal can be emotionally devastating and leave scars that last for life. Now we see a different issue entirely, not Emily's lures, but the department.
Okay. So when she's sick, does he come to your house to do pickups? Is that what you've traditionally done?
Yes.
Okay. So I run into the issue here, Mr. Green, is, you file this complaint, but everyone agrees that you didn't attempt the pickup during the summer. So I can't find somebody in contempt if you're not showing up to pick the child up. If there's a statement of, hey, the child's not going to go with you, that's still technically not enough. And you need to show up. And if the child's not there or made available to you for pickup, then you have a potential complaint in the future that I can exercise and find somebody in contempt for or address. But given what happened over the summer, I am going to dismiss the show cause against Miss Green, as it does not appear that you were making the attempts to go there. I understand that maybe you thought she wasn't going to be made available, but you have to actually make the attempt. So it sounds like this Friday is your parenting time. Is that correct?
Yes.
Okay. So obviously, if you go to exercise your parenting time this Friday and the child's not made available to you, then that's an issue for
Departments. Her attorney points out that CPS itself scheduled a visit at the same time as family therapy, effectively forcing her to miss one or the other. That's not a refusal. It's a system error. Add to that missed emails, poor follow-ups, and multiple professionals struggling to coordinate, and you get a case where the parent isn't the only one at fault. For viewers, this raises an uncomfortable truth. Sometimes reunification delays are caused less by unwilling parents and more by bureaucratic breakdowns. Housing stability always looms large in reunification hearings. Emily's journey through multiple rentals, including a small, smelly trailer and finally into public housing, shows how
parenting time violation and contempt. But at this point, I'm not going to find any contempt given the information that the pickups were not attempted. Do you have any questions regarding that, sir?
I guess not.
Okay, Ms. Green, any questions?
No, thank you, Your Honor.
All right, so it sounds like his next weekend is this weekend. If she's not in school, then the pickup would happen at mom's house. All right, thank you both for appearing. You're all set. Okay, it does appear we have the parties in the next matter present, so I'll call the matter of Brittany Burr versus Tyler Nash, file number 15-157.
Your Honor, for the motion
Is there anything else that you had filed, Mr. Nash? Was there any?
No, Your Honor, in the motion regarding support, I had some issues with having Ms. Burr served. I had mailed it out and it got returned back to me, and I'm working with a friend of the court on how to resolve that currently.
All right, what is your request regarding support?
Just that now the parenting time has changed, so it is equal 50-50 week on, week off. for both my children.
Difficult it can be for low-income parents to meet CPS standards. What matters here is not whether the odor came from her, but whether the new home provides a safe, stable environment for her daughter. With new furniture delivered and no major concerns reported, this housing change could be a turning point. But skeptics will argue, has the pattern of instability truly ended, or is this just another temporary fix? Notice how much time is spent on something as simple as odor. To outsiders, this may seem trivial, but in court it's symbolic. A nasty smell in one trailer raised questions about sanitation.
So, just asking.
All right, I do see there was a prior order indicating 182 and a half overnights with one child and 104 with the other, and you're saying it's 182.5 now with both children?
Correct, Your Honor.
All right, Ms. Burris, do you agree or disagree with that?
Yep, whatever the amounts of overnight that it was stated in there with Wyatt. Yep, we're doing the same with Walker.
All right, so you're sharing equal time with both children?
Yes, sir.
All right, so we'll do a new support calculation based on the equal time going back to his filing of that motion.
When
And then
was
Mr.
it filed? Sorry, sir.
It looks like September 5th.
Okay.
And then Mr. Nash, you had some parenting time complaints, is that correct?
Yes, Your Honor. I believe there is 4 complaints. I'm not sure if you want me to go through those one by one or kind of give you a
Yes,
snap.
sir.
Sorry.
All right, let's go through them.
Okay. So there's been I have 4 complaints here. The first complaint I'll bring up is the alleged violations would have been 12/9 of 2024 6/20.
Parenting standards, and the child's comfort. Emily's defenders argue it was the trailer itself. Mold, leaks, poor construction, not her lifestyle. And in fact, her previous home had no odor at all. This detail illustrates how small environmental issues can snowball into major credibility battles. Judges often have to separate cosmetic problems from true safety risks, and this becomes a defining test of fairness in child welfare cases. By this point, the record shows a mother who has kept a stable job for 4 years, engaged in individual therapy without missing, and secured a home. But it also shows missed deadlines, delayed trainings, and confusion around counseling. This duality, progress paired with gaps, is at the heart of so many reunification cases. Judges must
28 of 2025, just refusal to communicate about medical and governmental appointments. For the governmental appointments, Ms. Burris got both my children enhanced IDs without my consent. Didn't tell me about the appointment. She also made a counseling appointment and didn't put it we're ordered to use the Our Family Wizard app, Your Honor, and she didn't put it into the calendar until after my son had told me about it. Signed up for, my son was signed up for baseball, didn't put in the events into the calendar until 2 weeks after practices had started. And we've had those issues for baseball and most sports every year. Been trying to resolve it through multiple mediations. And in our February 11th mediation agreement, which became an order, there was a clause in there.
But is Brittany sloppy or strategic? That's the million-dollar question. The judge makes the only move possible here, setting an in-person evidentiary hearing. Why? Because without hard proof, all of this is just accusations and denials. At that hearing, Tyler will need witnesses, documents, and ironclad evidence that Brittany knowingly withheld information. Meanwhile, Brittany will argue she followed the order. These hearings are where truth collides with credibility. One parent will walk away validated, the other potentially sanctioned. And this shows just how high the stakes are, because repeated violations can lead to fines, loss of parenting time, or worse. By the time we hit the tobacco case,
That to have clear, direct answers, and Mrs. Burris still is kind of vague with that, like she's refusing to do that. And even in her response to that complaint, She never addressed whether or not Walker, my youngest son Walker, got an enhanced ID or anything like that. And she's still, making appointments last minute. It almost feels intentionally, that she does that sometimes, so that I am not able to attend or be included in that. I have another complaint for, let's see, not informing me about my son's school forms and the alleged violations are on May 7th of this year and June 11th of this year. And, around June 11th for this complaint, reached out trying to discuss Walker's class selection it would be now this year, since he's going to be taking some high school credit.
The courtroom has covered it all. Missed pickups, conflicting stories, hidden medical records, and even kids wanting to choose where they live. What ties all these cases together? Responsibility. Judges don't reward assumptions, excuses, or backdoor tactics. They reward consistency, documentation, and parents who actually follow the order, even when it feels unfair. And here's the big takeaway. If you want to win in family court, you have to play the long game, by the rules. Now, I want to hear from you. Who do you think came across more credible here, and why? Drop your thoughts in the comments. And if you found these cases as intense as we did, hit that like button, share this video, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Because trust me, what you just saw is only the tip of the iceberg.
And let's see, the counselor emailed me a signed form where Miss Burris had that, and it went home on May 7th. And when I asked Miss Burris about it, she didn't give me a response. And, it was brought up during a conversation on June 16th about missing information for Wyatt during a conversation on June 16th about missing information from Wyatt's summer camp. I had to ask that multiple times.
So I'm going to pause you for one quick second. So what is your request as far as what are you seeking from the court for these alleged violations?
Your Honor, this has been kind of one of those things where it's been going on for many years, and I don't always file complaints because I'm not a big fan of going back and forth to court. But it seems the only time that she stops is when I file a complaint, and then she stops for a short amount of period of time until after court. And then, you give it a couple months after court and she's going back to doing the same issues.
Are you requesting that she be found in contempt and fined, or what is your request?
Just some sort of a consequence so that this behavior stops from her. So.
Okay. That's the case, then what we'll have to do is set the matter for a evidentiary hearing.
Okay.
Unless you agree that you violated the order. If not, then what we'll do is set the matter for a evidentiary hearing.
I don't agree that I violated any order.
Okay, so we'll set it for a hearing. It's going to be an in-person evidentiary hearing to determine whether or not the order was violated, and then whether or not there should be any contempt sanctions. I have availability on October 29th at 11 a.m. Do either of you have any conflict with that date?
I'm pulling up my calendar right now, Your Honor. Sorry.
Sure.
I believe I'm open for that. You said 11 a.m., Your Honor?
Yes, sir.
Okay.
Ms. Burris, any issue with that date?
No, I don't.
All right, so we're going to set for a in-person hearing on October 29th at 11 a.m. If you wish to call any witnesses to support your side, you need to file a witness list. If you wish to introduce any exhibits, you need to file an exhibit list. Those have to be filed at least 14 days prior to the hearing date. Additional information will be provided on the notice, as well as you can potentially get some standard forms from the front of the court if you need them to complete those documents. Any questions, Mr. Nash?
No, Your Honor.
Ms. Burris, any questions?
No, sir.
All right, thank you both for appearing. I'll see you October 29th.
All right. Thank you, Your Honor.
Well, I'm going to indicate also, so I didn't realize that support motion that you filed, Mr. Nash, was actually noticed up for November, but since there is an agreement that the children are have equal parenting time right now, we will make that due support record